We will go on the record in the matter 25 CF 147, State of Wisconsin versus Rita Wenzel. The state appears through Assistant District Attorney Jose Vila in person. Ms. Wenzel appears by video conferencing in custody with her counsel, Nicholas White, also by video. We're set today in this matter, I believe, not only for a status, I think, if I'm not mistaken, Mr. White, you filed a motion to modify bond?
Yes, I did, Your Honor. If we could address that today.
Can I get an update on the case first, and then I will allow you to be heard?
Yes, this case is not resolved currently. I did receive an offer. At the last hearing, we were optimistic this might be a situation where Ms. Wenzel was able to get into treatment court. We've had contact with Tessa Anderson, and I know that that's not going to be an option any longer. We're not resolved today. We're still working on some negotiation options, as well as just discovery review. I recently received the search warrant that it wasn't the basis of the allegations here, but it was the basis of Ms. Wenzel's arrest. I'm still reviewing some of that to make sure it all adds up. So we're not currently resolved.
Okay, thank you. And Mr. White, I have received and reviewed the letter declining admission into the treatment court.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. What you're watching here is a high-stakes pre-trial moment where bond, leverage, and the strength of evidence collide. The defense is fighting to get their client out of custody after months behind bars, while the state believes the evidence is overwhelming. Treatment court is off the table, negotiations are fragile, and every argument right now could shape how this case ultimately ends. The question is simple, but powerful. Should someone sit in jail before being convicted, or does the evidence justify it?
And so you can understand or be aware that admission into the treatment court, you cannot be convicted of any intent to deliver any illegal substances. However, I'm just letting you know as an attorney that if somebody is charged with intent to deliver and that there is an agreement where they're not convicted of that, maybe a lesser charge, then they can reapply into treatment court, and that would possibly change things.
Okay, I understand that. Yep.
I didn't know if you were aware. I'm sorry.
Okay.
All right. Okay, so thank you for that update. Argument as to a bond request.
Thanks, Judge. We already had one attempt at this. I don't want to review too many things, Your Honor, but I still just want to remind you of some of the basics that Ms. Wenzel's past legal experience is 2011, 2012. I looked into those as misdemeanor resolutions. I don't see any missed court dates there. I don't think the state is really concerned about missed court dates in the past. My understanding here is more having to do with the strength of the evidence. I've had a chance to review the discovery. I see why the state feels very strong with the evidence in this case. I see why. But that aside, Your Honor, it's not a foregone conclusion that she will be convicted in this case, and I don't think it's fair for her to sit in custody basically as pretrial detention as though she's already convicted. She's been in custody since the middle of October. That's about 3 months by now. She's clearly unable to pay the cash herself or rely on family and friends to post that amount for her. There's no history of a flight risk from her. She does have strong ties to the community. We probably went over that last time, but just as a reminder, she owns her own house. She was responsible for caregiving and support of both her parents. She has more family in the area than just that. I have had contact with her family, specifically her daughter. I've had contact with her just yesterday. This is not a case I get. I don't have any kind of feeling here that this is somebody who's trying to avoid responsibility. I think this is somebody who's trying to figure out how to take care of this case and manage it the best way they can. I think there's a less restrictive way of having her handle this case and be present for court if Your Honor would consider lowering the bond even to $5,000 or $2,500. I know that's a big difference.
This is a critical bond argument, and the defense is hitting every legally relevant factor. No missed court dates, strong community ties, property ownership, family responsibilities, and no flight risk. Notice how the attorney carefully reframes detention as pre-trial punishment, which courts are supposed to avoid. At the same time, he acknowledges the strength of the evidence, because credibility matters. So here's the real tension. Is bond meant to ensure court appearance, or is it quietly becoming a pressure tool when someone simply can't afford it? What do you think the fair balance should be?
But it's still a lot of money for them to have posted. It's still a lot of money held, kind of keeping her on the hook to make court. There's no victims in this outside of the community in general. I don't think there's any witness concerns. So we'd ask for you to consider just reducing the bond. My last argument, too, is more of just a legal experience argument, Your Honor. When I have, for example, DUI cases, and it's fairly assumed that someone convicted is going to have to serve some time, Your Honor, just looking at the negotiations here, if Ms. Wenzel is found guilty, this is probably a case she's looking at some prison and serving a sentence there. And Your Honor, I'm just trying to balance that with an example from, say, an OWI case. In those types of cases, we always ask for time to report or time to schedule a plea hearing in a way where the person's able to get their home affairs in order before they have to serve an extended sentence. And that's part of my concern here, Your Honor, is that if she is convicted in the long run and does have to serve some time, that means that if she doesn't get released before then she's just in jail and then right to prison, and that doesn't give her any chance to get her household in order, do anything she needs to with her property, family members, and that kind of situation. So I am asking you to just consider lowering it enough that her family may be able to post it. Even if it was lowered to $5,000, I don't think that's a small amount myself. So just for those reasons, I'd ask Your Honor to consider that.
Mr. Vila?
Your Honor, the state does not oppose a reduction to $5,000 cash bond. However, Attorney White already alluded, the strength of evidence of this case is very, very high. We have a camera footage of the actual CI doing the buy with Ms. Wenzel. Given that alone, I believe a majority of the arguments that were brought up today were already heard by this court previously. State rests that if the court does order any kind of reduction, it should be a $5,000 cash bond only.
Right. Mr. White, you do make a very concise and a good argument, very eloquent, and you stated a lot of things that the court can consider. For the record, we do have her daughter is present here today in court observing or watching. Ms. Wenzel has been in this court before, but not for any serious matters. I haven't been aware of her engaged in any type of activity like this previously. She does own her own home, and I know she is a worker and a good worker. I'm not sure if her family would be able to come up with $5,000. That's what the state is arguing for. That is still a significant amount of money to lose. And with the evidence that at least I'm being told and stated by both sides, it's very compelling.
This ruling shows how judges walk a legal tightrope. On one hand, the court openly recognizes the defendant's work history, family ties, and lack of serious prior offenses. On the other, the judge repeatedly emphasizes how compelling the evidence is, especially with controlled buy footage. That matters because strong evidence increases incentive to flee, at least in theory. By landing at a $5,000 cash bond, the court splits the difference, granting relief but still keeping serious pressure on the defendant. This is judicial discretion in real time, measured, cautious, and deliberate.
The court is willing to amend to a $5,000 cash bond, same conditions. If in sometime in the future she's unable to even post the $5,000, the court would be amenable to hearing another bond modification request, again, because you've made such a compelling argument, Mr. White. But because of the evidence that I'm being told that the court has, or the state has, at this time, with the state's agreement to amend to $5,000, the court will do so.
Okay.
All right, we need another court date.
Understood. Thank you, Judge.
And you're looking at the warrant, just in case there are issues or things that you may need to file. Is that correct?
That's right, Judge.
All right, let me just get another date. Ms. Wenzel, were you going to say something?
Thank you, Judge.
And I will state for the record that I'm doing the $5,000. If I were to do anything lower, it would need to have some attachment to your home since you are a homeowner. So that's why I just went with the straight cash. Can you do April 30th at 11:15? Zoom is fine.
Yes, that'll work for me.
11:15? Yes. I'm sorry it's so far out, but we have some trials and things, and it's hard to get on Mr. Vila's calendar. All right, April 30th at 11:15. If we need to get in for an argument on anything else or for any other motion that you want to file, Mr. White, we'd be able to squeeze it in. However, we'd have to squeeze it in on District Attorney Week. And so right now I just placed you on the ADA week.
Okay, I understand.
All right, thank you. We are adjourned.
Thank you.
We will go on the record in the matter 25 CF 71, 25 CF 109, State of Wisconsin versus Linda Lightfeather. The state appears through. Yes. Can you not hear me?
No, I couldn't for a while. I think there was a setting that would need to be changed. Sorry.
All right. Mr. Aaron Marco, Special Prosecutor, District Attorney, appears by video conferencing. We have Joel Feliski, counsel in person, with Ms. Lightfeather also in person. We're set for a plea and sentencing. First and foremost, Mr. Feliski, does Ms. Lightfeather waive the right to have Mr. Marco in person?
Yes, Your Honor.
All right. What is the agreement that's been reached?
Thank you, Your Honor. This is a global resolution to resolve both 25 CF 71 and 25 CF 109. Ms. Lightfeather has agreed to plead to the sole count in both cases, plead to count 1 for possession of THC, second and subsequent, in 25 CF 71. In 25 CF 109, she's pleading to the count as amended down to illegal voting. That's an unclassified misdemeanor under section 12.1330 of the Wisconsin statutes. Joint recommendation between the parties for a $100 fine and court costs on each count. I have a completed plea questionnaire with me. May I approach?
You may. Thank you. Ms. Lightfeather, I have in front of me the plea questionnaire waiver of rights form that recites the agreement on the that was stated on the record. Do you recognize the document?
Yes,
Did your attorney thoroughly go over the document with you?
yes,
You understand everything completely?
yes,
Is that your signature on the second page?
yes,
You're pleading guilty to one count of possession of THC, second offense, an I felony, and one misdemeanor count of illegal voting, correct?
yes,
Formal motion to amend 25 CF 109, count 1 to the misdemeanor version. Mr. Marco,
So moved.
granted. You're 65. You can read, write. You understand the English language. No drugs, no alcohol, no other medications. Did your attorney thoroughly go over your constitutional rights with you?
yes,
You understand them completely?
yes,
Do you need me to go over those rights with you in any more detail?
no,
Do you understand that by pleading guilty, you're waiving and giving up those rights?
yes,
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
yes,
You understand that you're pleading guilty to a felony. As such, you will no longer be able to use or possess a firearm for life.
yes,
No longer able to vote in any election except for tribal elections until your civil rights are restored.
yes,
Do you understand that here the state would have to prove on or around May 6, 2025, you possessed a substance, THC. You understood and believed that substance was THC, and it was the second subsequent time that you possessed either THC or one of the enumerated other illegal substances in that statute.
yes,
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 3.5 years or both?
yes,
Do you also understand that in 25 CF 109, the illegal voting, the state would have to prove on or around April 1st, 2025 in Burnett County, Wisconsin, you intentionally voted in an election that you didn't have the requisite qualifications because you were a felon and you haven't yet completed your term and had your civil rights restored. Do you understand that?
yes,
And this is the misdemeanor version. Do you understand the maximum penalty could be a fine of up to $1,000 or up to 6 months of incarceration or both?
yes,
Do you further understand that I'm not bound to follow any offer that's been recited on the record?
yes,
I can, in my own discretion, sentence you to the maximum penalties if I thought it was warranted.
yes,
Do you still wish to proceed and enter guilty pleas?
yes,
Did you go over both criminal complaints with your attorney?
yeah,
In
Yes.
particular, those sections called the probable cause sections where it says what happened and why you were charged with the crimes?
yes,
Are those facts, for the most part, accurate?
yes,
Mr. Feliski, may the court use the probable cause sections of the criminal complaints to find a factual basis?
So stipulated.
Has anyone made any threats or promises to you for you to plead guilty?
no,
You're doing so freely, intelligently, and voluntarily.
yes,
Has your attorney represented you competently?
yes,
Are you satisfied with his services?
yes,
Any questions for the court or your attorney before I proceed?
no,
As to 25 CF 71, possession of THC second or subsequent, how do you wish to plead?
guilty,
As to 25 CF 109, the misdemeanor version of illegal voting, how do you wish to plead?
guilty,
Court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of both counts. Judgment of conviction will be entered today. Argument, Mr. Marco.
Thank you. I believe this is a reasonable resolution. She does have a prior criminal history that involves an OAR, THC, two THCs, possession of methamphetamine, and a felony bail jump. It's my understanding that in 2025, she was revoked from probation. I'm not 100% sure if it was related to this, but I think that it was. As the court had mentioned before, she's 65 years old. She's been a member of the community for a long time, but she's also suffering some significant health issues at this point in time. Certainly, I don't think that jail is necessary in this instance for THC and illegal voting. It's been brought to her attention that she didn't have those rights at the time. She's well aware of that now. I don't believe there's a high likelihood that she's going to re-engage in that behavior. I think that it accounts for the severity of the offenses as well as protection of the public. I would ask the court to adopt a joint recommendation given her particular situation. Thank you.
All right, Mr. Flisky.
Thank you, Your Honor. I first want to address the issue of jail credit. A review of CCAP indicates that Ms. Lightfeather on 25 CF 71 was in custody here in the Burnett County Jail from, I have here, May 7th of 2025 until cash bond was posted on May 21st of 2025, indicating that she spent 15 days in custody on that offense. I think that was a significant punishment in itself, Your Honor, given the nature of this offense here. I do agree with the state that overall, I think this is an appropriate resolution to this matter. It protects the public. It's appropriate given the nature of the offenses here, as the court has acknowledged and the state has acknowledged. Ms. Lightfeather has been dealing with ongoing health issues that would make additional incarceration inappropriate in these circumstances. I think the amount of fines and fees that she would have to pay back in regards to resolving this matter in itself would be a significant deterrent. Overall, I think that this is an appropriate agreement, and I would ask the court to follow it. Thank you.
All right, thank you. Ms. Lightfeather, do you care to make any statement here today? Let me know anything that you want me to know.
I have some appointments for my health. I think it's next Tuesday, and they're going to see about how my heart is doing. Right now, it's kind of rocky, and
It looks rocky, but I mean, it may be rocky, but you look really good today.
thank you.
Color in your face, and
Do I?
you look like you're free of any substances.
Yeah, I'm free of that.
I'm glad to hear that, because I was going to say, even though I know you're ill, you
Mhm.
look good.
Thank you. I think I feel a little bit better. It's just I'm slow talking and can't.
You need rest.
Yeah, that's what they say.
You need lots of rest, and you need to stay away from the substances.
Yeah.
All right.
Mhm.
And with this voting thing, you knew that you were a convicted felon, and
Yeah,
you knew your
and-
rights weren't there yet. But I don't think you did it to be
No, I didn't.
to take advantage of the system. I don't think you did it to be flagrant, and you were like, "Hey,
No.
I know I can't vote, so I'm going to go vote."
No.
But you are acknowledging the fact that you did go vote, even though you were not legally able to vote.
Mm.
And you're admitting here today that you did have at least THC, and it would at least be your second or subsequent conviction. I know and I understand your health issues, but again, you look good today. You must be resting. Keep resting. These are not the most serious crimes and serious allegations, but you are taking responsibility. You're stepping up. You're saying,
Yeah.
I understand. I did wrong.
Yes.
I will have it, Judge. Give me my salt. Let me know. Okay. And so I get that. And so for the most part, I'm following the recommendation. Here's where I'm differing. I am going to sentence you to 20 days of jail per count, time served. You already set that, 15 days. So you get, yeah, you're good. So it's the good time, all of that. So it's time served. You might as well get credit for it, right? You sat the
Yeah.
time. So it was a punishment, wasn't it?
Yeah.
Yeah, it was. You had to sit in jail. So you might as well get that credit. If people are looking at it, people go, "Oh, she got a free and clear, blah, blah, blah."
Mhm.
No, you didn't. You
No.
sat 15 days, 20 days in what your sentence would be. I am going to be a little bit more lenient as it relates to the fines and fees. I understand where councils are coming from. I get it. Court costs should be paid and covered for. Plus, there should be a $100 fine. I get it. You know, that's the punishment. However, I do understand your financial situation. I do understand that you are living on a very limited income.
Yeah.
I do understand your health issues. So that's why I'm being lenient here today. And that comes with having the judicial knowledge that I have in the brain of being able to know you for a little bit of time, okay? And to know what you're going through and to keep understanding that. So what I'm going to do is I'm assessing $250 per count, okay? For the felony, that's the maximum I have to charge. I can't waive anymore. For the misdemeanor, I have to do $200, but I'm going to add an additional $50 in court costs. You have $500 posted. You're good to go. All right. You don't owe any more, at least unless there's other surcharges. I don't know, but I think you're completely good to go. Okay.
Okay.
So you have 20 days to appeal. Should you fail to appeal within 20 days, you lose that right. I need your DNA. I'm pretty sure we have it, but I need your DNA. I need to at least try and get down to the jail today reporting, see if they need your DNA. If they do, they'll swab it. If they don't, they'll send you on your way. You do have the right to request that be expunged through a written letter to the Department of Justice, not to me. I don't think you care about that because you have the felonies and all of the other things, but that's your right to do if that's what you want to do. It does say I need fingerprints on the second case. Silly, I know, but with each and every open case, I need fingerprints. So when you're done here, you're going to come up to the clerk, you're going to grab 2 pieces of white paper, I think, or maybe just 1, and it'll say you need the DNA and you need your fingerprints. Bring that to the jail too. They'll do all of that. All right. 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I believe that's everything. Mr. Marco.
I think that is everything. Thank you.
Thank you. Mr. Palisky.
Nothing
Thank you.
further. Thank you.
Thank you.
We are adjourned.
Okay. Thank
I
you.
just did the Mr. Schmidt. Mr. Palisky. All right.
Stepping back, this courtroom session highlights 2 very different outcomes shaped by accountability, health, and legal posture. One defendant fights pretrial detention under the shadow of strong evidence, while another resolves her case through a negotiated plea that balances punishment, responsibility, and compassion. The judge makes it clear, consequences still matter, but context matters too. These decisions ripple far beyond the courtroom, affecting families, rights, and futures. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.